Now we're going to turn to the second category of torts, which are negligence suits. And here, obviously, it doesn't require that the defendant has done something on purpose, doesn't have to be intentional. All the plaintiff has to prove in order to make the prima facie case is that the defendant owed a duty to the plaintiff, that the defendant breached that duty, that the breach was both the actual and proximate cause of the plaintiff's injury, and that the plaintiff suffered damage to her person or property. And we're going to talk about each of those four elements: duty, breach, cause, damages. So first of all, duty. So when a person acts, she's under a duty to act in a manner that the ordinarily prudent person would act on under the circumstances. So the person's actions have to be consistent with whatever the standard of care is for somebody in that position, and the standard of care is what a reasonable person would think someone should do to take the basic precautions without being overly neurotic about it. Now, the standard of care for some categories of people might be higher. So, for example, the standard of care for professionals requires them to act with the knowledge or skill consistent with their profession. And if they don't, that's malpractice. And we'll talk a little bit about malpractice in a little while. The standard of care for children, on the other hand, might be a little bit lower because children of a similar age would be the standard, sort of what's reasonable for those kinds of children, and that we wouldn't necessarily hold them to the same standards that we would an adult. Now, people, generally speaking, are not under an affirmative duty to act. So, for example, if someone is in danger, you don't have a duty to help the person avoid the danger. But once you actually take action and try to help someone who's in danger, you do then have a duty to do it in a careful way. It may be that even if there's not a duty in the first place, a duty is created. And we talk about homeowners having a duty to maintain their property in a reasonably safe manner. It doesn't mean that absolutely every hole has to be filled in, but if a hole on your property is relatively big or it's relatively hidden, then you would be breaching your duty of care if you don't either fill it in or put a sign up or put a fence around it and so forth. And so this is all kind of a reasonable person standard. If the defendant fails to exercise the standard of care applicable, then that's a breach of the duty. And in some cases, we talk about a breach of duty being established by a principle known as res ipsa loquitur, another great Latin phrase that the law uses. And res ipsa loquitur means the thing speaks for itself. And the idea is that if a particular thing might occur, then it speaks for itself. By its definition, it's a breach of duty. So, for example, if the harm, whatever it is, would never occur without someone being negligent, then the fact that it occurred is in and of itself proof that someone breached a duty. Or if someone violated a statute, then that's probably going to be evidence in and of itself that somebody violated a duty and there was a breach. Now, causation, the third element of the prima facie case, has two aspects: actual causation and proximate causation. So actual causation we talk of as but-for causation. So the plaintiff has to demonstrate that but for the defendant's actions, this harm wouldn't have occurred. But the reality is that there's often a lot of factors that together result in a harm, and it's sometimes hard to figure out who really is at fault and which of the various breaches of duty that might have occurred really caused the harm to occur. And so when we think about proximate cause, we think about foreseeability. So what we say is the plaintiff has to prove that whatever the thing is that happened was a foreseeable result of what the defendant did. So it's not just that it was a but-for causation, but it's also that it's a kind of direct result and a foreseeable result of what happened to the defendant. In some circumstances, an event will occur after a defendant's actions that contributes to the plaintiff's harm, and that's known as an intervening cause or an intervening force. And it's possible that the defendant then won't be liable for the harm created unless that intervening force was also foreseeable. The fourth element is damages. So the plaintiff has to demonstrate that she suffered actual harm or injury as a result of the defendant's actions, and it's sometimes complicated because sometimes it's difficult to prove that this injury came from that accident or this harm was really caused by that activity. Sometimes it's obvious, if I slip and fall on some ice and that's what breaks my neck, then that's clear. But often it's less clear. For example, if I have lead poisoning and as a result of that, my child is born with some sort of a birth defect, it's sometimes hard to prove that the birth defect is because of the lead poisoning. And even if it could be proven that it's because of the lead poisoning, I might not be able to prove that it's because of the lead that came from the product that the particular defendant manufactured 30 years ago. So causation and damages becomes difficult in that sort of a situation. Now, as with intentional torts, there are affirmative defenses that a defendant can raise to a negligence suit. One classic one that was very controversial is called contributory negligence. And in contributory negligence, the idea was that if the plaintiff did anything at all that itself was negligent, then that wiped out the plaintiff's ability to recover. So if I am perhaps walking without in the street without paying much attention, even though you were coming at 80 miles an hour without looking and ran me over, the very fact that maybe I wasn't paying the most amount of attention possible might prevent me from recovering altogether. So contributory negligence was a very, very harsh mechanism that sometimes denied plaintiff recovery, even though the defendant was mostly responsible. As long as the plaintiff was even a little bit responsible, the plaintiff couldn't recover. In response to concerns that that was too harsh to harmed plaintiffs, states have moved towards what's now known as a comparative negligence standard. And so juries are often asked, well, do you think that the defendant breached the duty of, had a duty of care, breached the duty of care, was the cause, caused damages? But then the jury is asked, as between the two parties, assign how much negligence went to the defendant and how much went to the plaintiff. And let's say the defendant was 60% responsible, but the plaintiff was 40% responsible. Presumably the defendant's penalties, the costs that the defendant has to pay, would be reduced by that 40%. But at least it wouldn't be eliminated altogether, which was the case in contributory negligence. Another defense that defendants might have is called assumption of the risk. And this is an idea that the plaintiff knows the risk of injury and voluntarily engages in the action despite the risk. You may have seen various forms of assumption of risk in your lives. So if you go to a swimming pool that is a public swimming pool or owned by a company, you might often see a sign that says something like, lifeguard not on duty, swim at your own risk. or something like that. If you go to a baseball stadium, the ticket will often say, by coming into this baseball stadium, you recognize that a baseball might get hit and might strike you when you're in the stands, and you are assuming that risk. All of these documents and signs are written by lawyers, and they are intended to set up a potential assumption of risk defense so that if you are harmed by the thing that they have warned you about, the argument would be you assumed the risk. On the other hand, sometimes courts will say, well, the thing that the defendant did was so risky that the plaintiff really can't assume risk because it's just not behavior that we want to see anyone engage in. But you can assume a lot of risk. So for instance, skydiving would be a great example of something where someone will sign usually a waiver saying that the skydiving company that takes you is not going to be responsible if something goes wrong. Even still, if something goes wrong due to the gross negligence, really sort of bad, careless behavior, you might still end up being able to recover.